Friends, we are starting now. Today is 184th Friday group meeting. Today's speaker is our Ajit Kumar Sinha, Senior Advocate, former judge, and earlier also he addressed the same topic after the Indira Jaising judgment. Today's topic is modification and changes brought in by the judgment dated 12/5/2023, followed by the guidelines for designation of senior advocates by the Supreme Court of India. After this judgment, Indira Jaising's judgment, there are several developments, and recently Supreme Court issued some modifications, circulars. In fact, all over India, even retired judges also, they are requesting me what exactly this. So I immediately approached you, sir. You are kind enough, immediately accepted. So now you can initiate yours, sir, please.
Yeah. Good afternoon and welcome to the Friday group. I feel privileged for getting the opportunity to address on an issue which will interest and concern each of our fraternity members. Without doubt, the classification, as you all know, is twofold under section 16(2) of the Advocates Act. There are only two types of advocates, that is advocates and senior advocates, and that is provided also in the Supreme Court rules. Till date, that has not been challenged. Earlier it used to be an election, now it is a selection. That's the drastic difference between the two. Selection, why I say this, is for many a reason. Because earlier it was purely the judge's domain, and it was very opaque a system, and there was no transparency, which led to issuance of judgment by a three-bench of the Honorable Judge of this court, leading into Indira Jaising 2017-9. That laid down the criteria and the formula on a point basis to enable the committee to designate the applicant as a senior. Initially, an issue was raised that could you by IAs review it by moving application for clarification, modification. The law is well settled, you can't do it. You have the only remedy under review. But if you read the judgment at para 74, I'll read it for you, that itself gave a liberty to reframe, to tone it up, to correct it, and that is why this issue was set at rest by the court. That we are empowered because in the judgment itself that scope of reference was there. I'll just read it for them. Initially, there was a 4 criteria based on which 100% formula was made up. The first and foremost was, I am referring to the 2017, was the number of years of practice. It was 20 points altogether. The second was with regard to judgments reported, unreported, which indicated the legal formulation advanced by the concerned advocates in the course of proceedings of the case, pro bono work done by the advocate concerned, domain expertise of the applicant in various branches of law such as constitutional law, interstate water dispute, criminal law, arbitration law, corporate law, faculty, specialization, and other branches of law including human rights and public interest litigation, international law. All these were the criteria for evaluating the 40 marks points for the purposes of determining whether you are eligible or not. The third was with regard to publication of the applicant advocate, and 15 points were allocated for that. And the fourth was test of personality, that is interview, and your personality at the time of interview. That was given at 25 points. for the purposes of determining that whether you are fit to be designated. Now in para 74, as you all know, I wanted to read that, clearly provided two things. We are not oblivious of the fact that the guidelines enumerated above may not be exhausted. So the scope was left of the matter and may require reconsideration by suitable. So there was no question of not entertaining the IA, and this was even though argued, and they set it at rest because of para 74. Now these four criteria led to a little bit of doubts because some of the areas were not clear, which led to filing of several applications from the entire country, including the states and including the petitioner in person in Rajasthan. And they said we need to see this in the conspectus, how far it is possible to implement it without any problem. The first criteria itself left a doubt, which said 20 points at the maximum and period of experience 10 to 20 years, and beyond 20 years 20 points. Now supposingly if a person has 11 years, 10 plus 1, and a person has 19 years, that is 10 plus 9, so both will be treated at par or not, is a question which was needed to be addressed, and rightly so. If I have completed 15 years and if someone has completed 19 years and someone has completed 11 years, will you give them all that 10 to 20 marks? Then they now laid down that yes, there is a fallacy in it, and they now have equated it that we will add 1 point for every year, so that there is no discrepancy, no discrimination, because you are basing it on the experience and the period undergone. The second aspect was, which I say is again left untouched as a grey area. Speaking for myself, I still feel that there is a lacuna, even in the new judgment. I'll tell you, you have to ponder over it. They say the minimum period of eligibility is 10 years. But a person who will apply should be of 45 years. How do you reconcile both? Try to appreciate what I am saying. It goes, because you will be completing 10 years in 34 or 35, then you have to wait till 45. So both of them can't go together. Why they have put 45 is for the general application, as far as I understand. But they have permitted each and every judge to recommend, even though that will go before the full committee or full court. But that is an area which needs to be gone into once again. Then why do you put 10 years as a criteria? Because you have said that only 45 plus will be eligible, as in the case of judges. Now that convention is there. So 10 years was redundant, according to me. So 10 years is only for an exceptional advocate as defined in the new judgment, I will come to it, for which any judge can recommend based on his ability, experience, special knowledge or whatever it is, maybe the criteria. Now the committee has been formed, there is no change in the committee, as you all know. The Chief Justice along with the two senior most judges and the Attorney General, learned Attorney General in the case of Supreme Court, and the respective Advocate Generals of the state, one member of the bar, that also is to be appointed by the committee, not by the Bar Association or the AOR Association. Nothing wrong in it. That was earlier also in the 2017 judgment, even now. The second aspect which came for consideration was whether this 40 points and whether this 15 points for publication can be permitted, or is it too much? Advocates doesn't get time actually for going into publication. And how do you know if somebody has authored or not? It can be authored by anybody. The names can be, all these were deliberated upon. They said that A busy advocate who is now longing to become a senior advocate, he cannot go on writing books. But when you give 15 points, it's a major chunk. Where others will compete based on his writing who has no work. That's the interpretation. The judges to some extent agreed. Honorable judges said that, see, a genuine advocate who is busy in his advocacy and work in the court can never be getting time to author books after books so that I can give them 15 points. And that is the reasoning given in the new judgment. I'll show it to you. Then what happened? They said, no, but some people are writing it, some people are doing it. Why not you permit them? They said, okay, we'll do one thing. We'll grant 5 marks for the publication, which will be a nominal thing, so that it doesn't affect in the totality of the circumstances. And these 10 were lifted from category number 3 of the formula and brought into category number 2. So they enhanced 40 to 50, reported and unreported. Then a question, because I was part of the matter, a question arose before the Honorable Court, twofold question. There is a hierarchy of lawyers. Reported, unreported, what do you mean? It is not spelled out. There will be people who are briefing in the background who never argue. They are completely wiped out. And a very nice evolution, I must say an original thinking has been evolved, and that is twofold. If somebody is a good drafting advocate, he has knowledge of law, maybe he has innovation, he cannot speak. But the drafting, even for AOR examination, one of the paper is drafting. So what happens to them who are behind the back drafting and they are competent to draft? Now a new criteria has been evolved for them, which is a welcome criteria, I say. If you feel that you are a good draftsman of a petition, either writ petition or SLP, with knowledge of law, then you can give 1+4 your synopsis, either as an advocate on record or non-advocate on record. And those synopsis will be gone into to test whether you are eligible or competent to get points based on that. Then they equated the government advocates and the panel advocates, who in every case are giving appearance, as has been suggested. They said, no, we will balance that by laying down these other criteria for reported, unreported. Because unreported means what? Names are 110. Many people give their names for the sake of giving. They have never opened their mouth. Then these are the additional criteria which was laid down, because 50 marks for that purpose was the deciding factor. So they laid emphasis. Earlier it was the para 73. I want to read that para 73.3 to 7 of the earlier judgment actually laid down the criteria, and 73.7 laid down these criteria that the permanent committee will examine. Now examine all applications including written proposal by the honorable judges, and the Secretariat will evolve and they will shortlist and place it. The database will be prepared. They will not give the marks, but they will prepare the database. That is the Secretariat. And then the permanent committee will examine each case in the light of the data provided by the Secretariat. So the data is to be prepared by the Secretariat, not the courts or the committee. That is very important, I tell you, because you are not the sole person who is preparing the data of the applicants as to whether he has given 10 reported judgment, unreported judgment, based on which how much fund. Then it is placed before the committee. And the committee will examine each and every case of the applicant based on the data provided by the Secretariat of the permanent committee. And thereafter, they will evaluate based on the 4 criteria to finally award the marks. Then a question arose that interview to the extent of 25% is too much. Many reasons were assigned. I don't say the reasons were wrong or good, but they said some people will be knowing somebody from their state, some people will be knowing somebody, so they will also have a bearing on this. They said that is of no knowledge, no purpose, for two reasons. The committee's recommendation will go to the full court in any case. That is how they were said. And then it is a personal evaluation because you are appearing in the court, most of the judges know you by face. If you are stationed in Supreme Court and you are appearing regularly, they can see you and then realize here he is a regular person. That is the purpose. So they said no, that can't be tinkered with. It has to be there and 25 marks has to be retained. Although there was too much of opposition, and rightly so, they retained that for many a reason. One of the reason was that it is a 3-tier test. Database is prepared, then the full standing committee, two senior most judges with the Chief Justice and the Attorney General, and then one of the members of the bar. Then it will go to the full court. Then came the question whether it should be secret ballot or not, and how many times the exam should be held, because earlier it was 2 years. In the 2007, two times per year. This secret ballot should be a rarity, an exceptional thing. It should be a deliberation by the full court, prepared by the committee, and the full court will go. Then they said that twice a year is very difficult. It will pile on. So what we will do is minimum of 1 year, that is how they distinguished it. Minimum of one chance in 1 year. It can be 2, but minimum is 1. Restricting it to be cumbersome, because the details and the data to be prepared every time, twice a year, will be a difficult task. So they said minimum of 1 every year. Then came what about the judges, the retired judges, the tribunal members and all those things. In that case, they evolved a different theory, that you people, whosoever has been a judge, will send a request letter to the committee. But I have been a judge, retired, and they will have to give an affidavit they are not employed anywhere, nor they are doing a job for gain, either joining tribunal or anywhere or something like that. If you are, then you are disentitled. A nice way of putting it. And if you are coming to Supreme Court as a practitioner after retirement, then your request letter is still directly to the committee, not to the database secretariat, directly to the committee, which will be placed before the full court, and they will be. So their passage was a different passage, and rightly so, and it is smooth. Then came the question of this 20 points. I have explained you how it is to be now calculated. 50, why? Now in 50 they laid down 3-4 more criteria, because you people should know it who is applying. It concerns you, it interests you. The first, I have said it to you, the grey area with regard to 45 years and 10 years. It doesn't reconcile. I am eligible in 35, why shouldn't I apply? You say minimum of 10 years. Even for a judge, minimum of 10 years. But you make a rider giving 45. Second is exceptional and eminent advocate, where any judge can recommend. That is a matter to be debated, or whatever you call it, but there are exceptions everywhere, and exceptions makes a rule. No problem in that. That is the reason for them to keep 10 years as the minimum. So the eligibility is there. What I realize this, that may be one of the reasons. Then the application for designation, which is already lying there and has not been considered or deferred. They have given that guidelines in the 2023 guidelines, that you can update it, replace it. But those cases which were considered and not recommended, they cannot be allowed to again reintroduce themselves as an applicant unless 2 years have lapsed. So there is a distinction between the two. There are cases which is deferred, there are cases which are not considered. They can update it, renew it, as in the present case for good number of years nothing has happened in spite of many applications pending. For them, they have said that yes, you can update it, replace it, it will be considered. But those cases which has been rejected or you can say not favorably considered, they have to wait for 2 years in order to renew their prior application for being considered as a senior. Now came the question of 2/4. They said you describe the cutoff marks in advance, because the cutoff marks is nowhere displayed. Supposingly, if the cutoff marks for designation of a senior advocate is made 60, then all those who get 60 and above should be recommended. They said it will be an exercise which will be full of discrepancy and it can't be disclosed because this is for future to happen. Depending upon the number of applicants, depending upon the number of interviews called by the full court, and depending upon the person who are to be recommended, because it can't be recommended as a n blocks. It is not a passing marks that you secure 60, you are through. So don't equate it with that, and rightly so. That is why they say we cannot disclose the cutoff marks in advance. Heated debates were there that it becomes opaque. They said no. Cutoff marks will be dependent on the eligibility, the number of candidates, the applicants, the number of interviews called. They also laid down that all the applicants who are the applicants cannot be called for interview. It will be based on the number of applicants that will call for the interview who are almost shortlisted, and that is the criteria restricting the number of interview, keeping in mind the number of seniors to be designated. Try to appreciate what I am saying. Number of seniors to be designated is to be determined. Supposingly they say in this year 25 people will be called. So now 75 will be called for it. There they have exercised their discretion. Because otherwise it will never be completed. Because it can't be a secret ballot any further. In that background, this is plausible a ground to justify it. People may have reservation, I must say that. But if you speaking for myself, that is a possibility and it should be considered like that. For the reason that if there are 200 applicants, it is impossible and the judges don't get time to take interview, each and every interview if they call for it. It will be difficult. Supposingly in the 75 marks, apart from the interview, somebody gets 10, somebody gets 15, which is a below average, then where is the need for calling them? Try to appreciate what they intended. It was in that background they say that the number of interviews will be dependent upon the number of people who are to be designated. So there was a justified, plausible reason assigned to say why we will restrict it like that, and there will be no cut-off marks in advance. And there, I don't know your opinion, I prima facie feel that yes, it was correct also. Because now you have also raised the question that it should be open, it can't be a secret ballot. Then full court meeting, secret ballot, all these things has to go together, otherwise it will be unworkable. Then came, what do you mean by ability, standing at the bar or special knowledge or experience in law? That was bifurcated. One is an arguing advocate, one is a very good draftsman, one is a very good briefing counsel. There are many states where you have threefold, in Calcutta, in Telangana also you have, where the briefing council is different, the drafting council is different, and the instructing council, and they all go to the senior. But their role is not in public before the court. That is why they incorporated these criteria as well. So now anybody who has never opened his mouth will also be considered based on your drafting ability, based on your knowledge of law and ability to at least draft something which has a bearing on the judgment.
Right.
So that was one of the ground which is a welcome decision, I must say. Then came a question that what about setting of the permanent committee and the composition of the Secretariat? That the court said that you have to leave it for us. It is an administrative jurisdiction of the court. Who all will be in the committee, whether a district judge will, retired district judge will be appointed, or the Secretary General cannot give so much of time. So that will be left to the court and the committee to decide and finalize. One more thing which has come in the 2018 guidelines. Judgment you all have read, that has followed a guidelines. Because these things which I have discussed, you may not get it in the judgment, but in the guidelines they have incorporated it. And what they say is, to fine tune, we have done this. All the proposals and the application will be published. And you will be, now I am telling you the procedural requirement. And an application has to be made within a period of 21 days from the date of notification. Proposal received for designation on the official website, and the Supreme Court invites suggestion, views of other stakeholders on the proposal for designation. At least 15 days time will be given to you all to apply and to give your suggestion, views. 21 days is the outer limit. Now, when the compilation is made of the database based on the application and all, additional information is collected, and pursuant to the direction of the committee, the Secretariat shall put up the proposal before the committee for scrutiny thereafter. Committee is bound to examine each and every application, which was not there earlier in the 2007. They said they just, it is taken as a whole in a bunch. Each application has to be considered because 75 marks is the purpose for this. Then only after scrutiny the 25 will be left, which will be done by way of interview. So each and every application has to be considered whether they come within an eligibility, thought of eligibility criteria. In order to base that, they have to consider each and every application and make an overall assessment on the basis of point-based formula indicated below. So now there is a departure from the earlier that you have seen, that I have already stated that 20 marks will be now divided like this. Beyond 20 years will all be getting 20. But if it is 10 plus 1, it will be 11. It will be 10 plus 5, then 15. That is a good reason to justify it based on experience. The second, you know, it has been updated from 40 to 50. 10 has been taken away from the publication part of it, that is the third criteria, and put it in the second criteria. Interview will follow next. So these database and the scrutiny for 75 points will be done initially to enable them to call people for interview. That is why they say that all the applicants can't be called for interview. Supposingly 100 applications are there. I am giving you a practical illustration. 100 applications are there. The database is prepared by the Secretariat and given to the committee of 5 members. The committee goes into it. If out of 100, they find that 30 are less than even 20 marks or 25 marks. So why to call them for interview? So only the relevant and 75 who are above 35 marks, who if they score good in interview can still be eligible, will be called. So it is always commensurate to the number of application and the number of applicant and the interview which will be called for. So that is how they have raised it. And that, in fact, it will shortlist the number of candidates accordingly for the purposes of final selection based on interview. At clause 19, they have reiterated this fact that those who are not favorably considered, a nice way of putting it, or not allowed, whatever you call it, shall be reviewed and reconsidered. So they are not ruled out. Even if you are not considered when you have applied, then you will be reconsidered after expiry of 2 years. I have already said that. That is clause 19. This will not prevent the advocate from making an application to a high court for designation as a senior advocate. A rider is there in favor of them. They can still apply to their respective high courts. So it's not barring them for all times to come. And all the cases which are deferred or not considered, they can update it, they can review it and apply again after the expiry of 1 year. Oh, no, so until the expiry of 1 year. If supposingly if a notification is there to call for interviews and call for selection, then you can withdraw your old application, renew it, update it and again apply. That is what is this criteria. I told you about the judges. Now there was one question whether people who have specialized knowledge and are practicing in that field, what will be their criteria to be judged for the purposes that 50 marks. There are many people who are expert in NCLT and NCLT IPC code. There are some in TTSAT, some in lower courts. There also they made a provision that their work in their specialized field will also be taken into consideration. So they are not ruled out. There are many from here in Supreme Court are practicing mostly in NCLT or NCLT. So that is not ruled out. You can also update your biodata by showing that how many tribunals and all also you are conversant with. So that specialized field is also being projected. Then comes the final decision, whether to be communicated individually to all the applicants. They said yes. The final decision of the full court will be communicated. This is serial number 24 guidelines. To all individually, all applicants. So that also, meaning there the opaqueness has been reduced to a considerable extent. That was the purpose of fine-tuning the earlier judgment. They also left a rider at serial number 21 that the full court may have power to review. Power of review is always there, even 137 you know, and Supreme Court rules also. To reject or to allow. That is clause 25. Review its decision. Supposingly if a lawyer is involved in a contempt petition, he abuses somebody, then they have the power, even otherwise the judgment is there in R.K. Anand's case and all those cases. So that is why this was included, but that has special circumstances unconnected with the designation as such. So now whosoever is willing to apply should first fill up the forms now I am giving you a practical suggestion. How to fill your application is very important. So you should read not only the judgment, you read these guidelines which you had said, some of the judges have sent to you. I went through it. Guidelines should be called the guidelines for designation of senior advocate by the Supreme Court. Now this guidelines elaborates each formula and each criteria and how to fill your application in the light of those 75 marks. 25 you keep it aside because that when you are eligible in the 75, then only you reach there. So you have to be very careful. In the first criteria, you have to show the actual number of years to get that maximum of 20 marks. The second criteria, there are 8 criteria inbuilt. You fall in 1, you may not fall in 2, you may fall in 2 or you may not fall in 3. all those which you fall in has to be specifically given with the enclosures, not only writing that. Supposingly you have appeared in 10 matters as an advocate on record, but there is nothing in the matter which reflects that you have argued it. What will happen? It will go a waste. If you have argued it and if it is not a reported judgment, still then you can enclose it, because even if it is unreported and if you have argued your name is figuring it, then you will have to be considered for the purpose. There are people who are empaneled as government advocates. There are many who are giving the names, there are many who don't even argue, there are many who are arguing. You have to spell out that I have drafted it. You will be treated at par with your synopsis which you have prepared by giving 1 plus 4 in that particular year. Now you have a specialized field. That also is included. Supposingly in NCLT and NCLAT you are appearing regularly. Today it is a very favorable destination for everybody to go there. You can certainly equip yourself and place all those judgments, orders where you have appeared actually and enclose it. It will be considered. There are 8 things which have been mentioned. I want to re-emphasize very, very carefully you have to apply. Here comes your discretion and application of mind to apply. Reported, unreported. There is a word excluding orders. Excluding orders. If you are enclose an order which does not lay down any principle of law, it will be disregarded. Pro bono work. You are doing for people, legal aid, whatever it is, that also is permitted. And the domain expertise, that is all the domain, constitutional law, interstate water dispute, all these tribunals, everything. Domain expertise will also entail you the same value and marks by confining it to that branch of law where the expertise you have reflected through your judgments. That will be. Earlier it was not like that. Those who have never appeared or opened their mouth, for that also there is a provision. And that provision I told you their synopsis and list of dates. So they have tried to streamline many things, but I must say that you have to apply in a very meticulous manner, understanding the requirement in order to enable you to get those points, the maximum.
Sir, why the cases are
Excuse
only
me.
for last
After
5
this,
years?
just I am finishing.
And
Then personality and suitability on the basis of interview for a holistic assessment of the applicant. That was actually argued at length. Holistic assessment of the applicant is twofold. Majority of you are known by majority of the judges because you every day interact, appear, whatever it is. The sooner they say, Acha, this fellow appears regularly. That's holistic assessment. Apart from their proficiency and your address and demeanor and everything to the court, all these will be considered, which is not written in black and white, but naturally. Human psychology is always there at the back of the mind. Human psychology will be that yes, he is well behaved. It matters how you deal with in the court, whether you have opened it gracefully. All these factors will weigh in their mind for a holistic assessment. There you can secure good marks, provided you are eligible in the 75 years. That's the long and short of, because it concerns each and every person, and I find many people sitting here. Whosoever completes 10 years may not be eligible. Again I reiterate. Because there the choosing is from the judges. If you are eminent, your ability is exceptional, then within 10 years also they can bring you. But there they will have to recognize. It's the other way around. You get my point? But there is always scope for that. Nothing wrong in it. So you will be eligible only after 45. as an applicant. But somebody exceptionally good, why not? That's the long and short of it. Any query? Now,
First, Hema, you want to ask
Yeah.
question, please.
So I want to know, where they have said cases, why have they written only for the last 5 years? That has been excluded
One second,
now.
one second. Sir, yes.
you see, when you apply, you are applying in 2023. So naturally, it will be the last 5 years which will be the purpose of determination, not prior to that, because then it becomes stale. You have to give for the last 5 years whatever you have done and apply for it. Nothing
I
wrong.
think the last 5 years is something.
If you have not done good in last 5 years, how do you expect that prior to that 5 years you will have done much better?
Fine. Sir, I have got a second question also. Like you have said, a certain number of advocates will be designated. So are they going to announce while the application is there, this year only 50 advocates are going to be designated?
No, there are two things. Neither they will announce the cut-off marks nor the number of advocates. It will depend upon the need-based and also that it should not become too much. And also how many applicants are there. It will be in proportion. That is what in the guidelines they have laid down. That the number of interviews called for will be based on the number of designation, which they have to determine. That is the committee and the full court. So they will neither disclose or nor announce in advance that we will select 25 senior advocates for this year, or we will say that the cut-off marks will be this. They will not disclose because it is dependent upon something
Please.
which is after 75%.
Yeah, please.
So will they disclose the total marks obtained by 2022?
It doesn't say so. It doesn't say so. I'll tell you why. Supposingly, if they have called you for interview, meaning thereby you have secured at least 35 to 40 out of those 75 marks, because that's the criteria in the initial. So that they can't even disclose that how much you have got. You will come to know that out of 75 I have not got even 30 or 20, so I was not even called for it.
Yes, Srivastava, please.
Is there any criteria instead of book writing and paper in international court or any international conference?
You see, now it has been reduced to 5 marks. Earlier it was 15, as you all know. That 5 marks will be the outer limit. So it can be of anything, whether international journal or Indian journal or relating to law, anything.
Teaching, yes.
Even
How about the PhD work?
Now it's
One second. After that.
10 has been reduced.
easier
10
than earlier.
10 has been reduced. 15, now it is 5. 10 has gone to the second criteria. So it is irrespective if it is in relation to a law.
Please.
Yes.
How about the PhD work?
But that has not been included. Not
Any questions? Please?
any lawyer,
Sorry,
whether
what
he is
about the
LLM or
mediators?
PhD. PhD can't be in law because it will be LLM. So that is equivalent to PhD. So there is not specifically mentioned.
Sir, what about the mediators? They are including in that, considering
You have to give it. Because some of the things they specialize field. That is why I said how you apply.
Sir,
You have to mention that I am good at mediation, I have solved 10 cases.
Yeah.
So that itself will be an indicative factor of a specialized field which is incorporated in serial number, criteria number 2.
Sir, one more, whatever the data is being provided, it will be published in public domain,
No, data will be sent to the committee.
not in the public
No.
domain. And there is no going to be no objection or something, I read some objection
No.
from the stakeholder or something.
You can update your application. You can revisit your application within the stipulated time. That's all.
Sir, thank you very much, sir.
Welcome all of
Immediately
you.
accepted our request. We are grateful to you.
It's my
Second
pleasure.
time and earlier
And
reconvene.
this topic relates to the fraternity. So it is a matter of interest for all of you, including me. Yes, madam. you were
Mr.
saying
S.P. Jha, Secretary Jha
something? Yes.
will say vote of thanks. After
No,
this,
he
you may
wants
ask.
some questions to be
please.
answered.
Come quickly. When I ask, you should.
Good evening, sir. Sir, my name is A.K.Sinha. So my question is, sir, that in next 15 to 20 years, like when we will be eligible to apply, so how you see the method of designation, first thing, and what is your advice for juniors of like us, you know, so.
You see, it's a premature question, number one.
अभी enroll हुआ sir.
And I'll tell you why.
1 minute.
It-
After this question.
I'll tell you why. But it is good that you want to know how to apply.
हो गए सरकार.
So you have to apply, but you have to see what are the guidelines based on which you prepare yourself from now onwards, so that after 10-20 years you can be eligible to apply and you will be considered favored.
Criteria may also change.
Pro bono define नहीं किया. You can take up any pro bono which you have done, like a PIN, legal aid. The criteria has not been spelled out, but pro bono means where a cause of public nature, public interest is involved. Certainly it will be considered.
How about the drafting?
Drafting, I told you, that is your synopsis.
Separate.
And you have to enclose that synopsis which you have drafted. 1 plus 4, 5. This you won't get in the judgment, it will be in the...
Secretary Jha will give you a vote of thanks.
Yes.
Now, sir, 1
Please,
plus
it's over.
35.
In the canteen, please.
Thank you, Mr. Sinha, sir. It's a usual, you are very elaborate, and it's basically we have traveled a journey from a Sipahi to the commander, because you have explained every aspect of the profession. And this has happened only when a person who struggles and reach the pinnacles, he can explain every potholes on the road. So it's very good. And second thing, which you have very nicely elaborate, it's in the Amrit Mahotsav of the 75 years of the independence, where the unsung warriors have been recognized. This judgment has also have recognized the unsung lawyer who has not done performance in the court. Those who are in a drafting, those who are in a research, those who are in a theory this.
That is
It's
an
a very
achievement,
good
I must-
achievement of this judgment.
I must tell you that is a special feature of this. That even though you have not opened up very frequently, still you are in the zone of consideration. That was a good move, and everybody then appreciated what Justice Kaul was saying.
One more caveat
please,
from my
please.
side. This also has basically changed our perception, because when we joined the profession, all of us, it was told us that those who are arguing, they will be designated. Those who are not arguing, they will be treated as a solicitor. Now you have basically this designation is a conferring the recognition that you have achieved something excellent in the profession, whether either on the dais, whether in your office, whether in your drafting. It's a very good judgment and good elaboration from your side.
Thank you, and why
Thank you
I
very much.
started with that. It is no more an election, it is a selection.
Thank you very much, sir. Take your autograph. Kindly join for cup of tea.